Good evening and welcome to episode 53 of the Political Mic podcast. I'm so excited to have with me a very special guest, Professor Josephine Ross of Howard University School of Law, who currently teaches criminal procedure and evidence at Howard Law. She also teaches a seminar where students explore current topics in policing and punishment. For over a decade, Professor Ross co-taught Howard's Criminal Justice Clinic, where she supervised students who represented clients charged with misdemeanors in Washington, D.C. Superior Court. She then launched a legislative clinic where students worked with the Justice Roundtable and ACLU on sentencing reform and other projects. In her book, A Feminist Critique of Police Stops, Professor Ross examines the parallels between stop and frisk policing and sexual assault. Professor Ross demonstrates why the Supreme Court got it wrong when it allowed police to stop, search, and sometimes strip search people and call it consent. Using a wide range of sources, including her law students' experiences with police, news stories about Eric Garner and Sandra Bland, social science, and the work of James Baldwin, Professor Ross sheds new light on policing, and this book should be read by everyone interested in how court-approved police stops sap everyone's constitutional rights and how this form of policing can be eliminated. Professor Ross, it's such a privilege and honor to have you join me today. I want to start off the conversation by asking, in your book, you talk a lot about Terry stops, which a lot of folks understand as stop and frisk stops. Why is the legality of Terry stops foundational, in your view, to what is arguably the greatest social problem of our time?
Terry stops is part of a wider problem. I focus in on it because the problem is that for too long, the issue has been, if we just get away from some of the Chicago and New York Terry on steroids, stop and frisk on steroids, if we just bring it back to what the Supreme Court originally conceived of it, we'll be fine. There won't be a problem. And what I say is no, because running through the whole stop and frisk theory is really the notion that people are going to give up their rights. That's the only way police can get from stopping somebody with either no suspicion at all and hoping that the person person doesn't walk away from the police, because of course walking away is dangerous, crazy to do, but the Supreme Court pretends that people have a right to walk away from the police unless they say stop, halt, or something like that. Secondly, even if the officer has reasonable suspicion to stop them, and so they still don't have probable cause that there's a crime. They still don't have probable cause to get into somebody's pockets. But what they want to do is get into somebody's pockets. That's the whole purpose that they're stopping. It's part of the war on drugs. And how do they do that? Well, the only way you can go from having something called reasonable suspicion to getting probable cause is if the person waives their rights. And that means either say, yes, you can search me. And the consent doctrine is crazy because people can't really say no to police. And if that was a secret at one point, now that we have all the videos of the police violence, nobody can say anymore that it is safe to say no to police. If they want to get into your pockets, the most young people, particularly young men of color, are told, say yes, do whatever the officer wants, just say yes, and that way you'll live. And so to then turn around and say, well, the officer didn't have probable cause, but the person waived their rights. They agreed, the officer. That's very, very cruel and puts the burden, it basically blames the victim. That's why I call it a feminist critique. It's blaming the victim, just like we used to blame women for, like, why did you walk in that area of the city? Why did you walk at night? Why was your skirt so short? That's what we're doing to young people here. We're saying, why were your clothes baggy? Why did you not push and fight back to the officer? And so that's where that parallel is coming from. And because it's really pernicious, the only reason that the police are stopping is either under the control idea that they're going to control swaths and show we're in power, we're in charge, which is improper. That's an unconstitutional use of stop and frisk, but that is what a lot of police departments do. But even if we go to the quote constitutional, which is that they have some kind of reasonable suspicion, it's really just an excuse to get into pockets. And I think it's better for people to have their integrity, and that includes bodily integrity. When you are frisked, it is there can be very, very invasive. I talked to Howard students about what it was like, and even when these frisks were really short, and we're talking, less than a minute sometimes, it can really be upsetting and trigger for a long period of time.
Mhm.
It isn't like, oh yeah, you get frisked and then it's over. Police are told to frisk in the groin area, be very, very thorough in the groin area. That is so invasive. And if we look at things honestly, it's much better that drugs just stay in people's pockets and we protect our society from this really sort of ugly part of policing that doesn't get talked about much, which is how sexually invasive it is. And
Right.
and I also say that stop and frisk is sexual harassment. Somebody walks along the street, like I when I was doing the Know Your Rights trainings with other
Mhm.
Howard law students. Howard really runs this book, Michael. So when we would go train Know Your Rights to young people in the community, youth court is where we go at DC Superior Court, and we were going there every other week. I had a young person that I said, how many times have you been stopped in the last year? And he thought about it. He said, about 10 times.
Mhm.
And then there's a pause and he says, I try not to go out if I can't help it. And so think about what that does to somebody, that they are so harassed. They never know whether they're going to be stopped, whether it's going to include a frisk that's very physically invasive. They don't know, when that next touching is going to occur. And this is really what stop and frisk is. So I'm trying to shed a new way of looking at it and say, the first thing we have to do is get rid of the consent doctrine. Consent should not be an excuse for police officers not to have probable cause. As you know, the Fourth Amendment says probable cause to search, right? You're supposed to
Right.
have probable cause. So then officers claim consent as a way around. And if they say consent, then it hides racial profiling. It hides the fact that they have nothing but a hunch. It hides everything. You don't need anything if you can claim consent. So we should just get rid of the consent. And it's not that hard to do. I've written some legislation, in fact, and I recommend that it pass in DC. I just provided some testimony in support of amending a law that's been proposed recently that would get rid of consent for juveniles, which is terrific. But I'm saying it should include adults too, because nobody can say no to a police, especially if they've seen videos and realize that police retaliate. And there's no way for you, an individual, to know if you're interacting with an officer that will retaliate against you if you don't do everything he wants.
Thank you, Professor Ross. And I just want to go ahead and shed some light on the fact that this is what the cover of the book looks like. It's a fantastic read. I want to also just go ahead and try to, I guess, tease that a little bit more. The mentioning of, rights not being really 100% when it comes down to interactions with law enforcement. I know that you argue in the book that it's impossible to exercise free speech, your First Amendment right, the right to silence, your Second Amendment right, demand probable cause when police seek to search our bodies under the Fourth Amendment. Can you elaborate a little bit further on why those rights are not really 100% guaranteed to exercise in those kinds of engagements with law enforcement?
Because they're not honored. So you have this great case law that talks about our First Amendment rights to tell police what you think of them. And it's beautiful on paper, but officers retaliate. And officers retaliate because they are trained to command respect.
Mhm.
They are told that their job is dangerous unless they're being given respect. And there's a racial aspect too to this, and a gender aspect, because what police consider to be respectful enough can vary depending on the race, gender, and age of the person. So when our young people come in and we start modeling, like, how would you interact? And their first reaction is either to run away from the police, and that's a problem, but also to say, I know my rights, you can't do this to me, etc. And that is perfectly allowed on paper, but it will get you in trouble if you do it in real life. So there's a lot of the idea of rights on paper versus the lived experience is totally two different aspects. And what I'm trying to do with the book is write about these rights. So you're right, Fourth Amendment is only part of it, but write about Fourth Amendment and these other rights from the point of view of the person who is stopped. Because as you know, the Supreme Court looks at it totally from the vantage point
Mhm.
of the officer. What did the officer know?
Right.
What he did reasonable? What did he know when? And they never look at what the individual who says, okay, search me, is going through. And to the extent they do, they never look at it realistically. So I'm doing an inside out review of the constitutional rights. And in the end, we don't have them. We have them only on paper. And
Mhm.
so the fix, we've lost the Supreme Court. Once Hillary Clinton did not win, we lost the Supreme Court for many, many years to come, unless there's a court packing scheme. So that means that this has to be all changed legislatively. That is the result. But you have to understand what we lost, what we envisioned to be bodily integrity, our right to be free from unwanted searches and seizures. And this is all compared to police and what police are supposed to have a constitutional limitation placed on them, but it ends up being fairly meaningless. They have pretty much unfettered power.
And that word reasonable always, when I was a student in your evidence course in criminal law classes, two of my favorite classes during my time at Howard Law School, that word reasonable was just seeming to have so much weight. And even when we go back to the Terry versus Ohio Supreme Court ruling in 1968, where the court said, that, whether or not officer's actions are reasonable would pertain to whether or not, the officer could feel like they were in imminent danger, uh,
Yes.
that the victim was armed. Of course, that involved a case where you had a detective who was on a downtown beat in which he was patrolling for many years. He noticed two suspicious men, and he kept observing them take turns walk past a window in a store until he decided to go ahead and pat them down, and that became, I guess, what we know now as stop and frisk. Um, that reasonable kind of determination of whether or not the officer's actions pass constitutional muster. Have you seen that kind of transfer to regular, ordinary, people acting as vigilantes, just to tie it into current events? Uh,
Mhm.
because there seems to be such a low constitutional bar that officers have to meet in conducting these kinds of searches. Have you seen in your book, do you analyze how that actually transfers over to people taking it upon themselves to act as judge, jury, and executioner?
They are related, but they're two different issues.
Okay.
So you're absolutely right, though, that there are problems that have to do with the way we think about excessive force in policing. And what we tend to do is we look just at the moment when the police officer, let's take the Tamir Rice case, where the officer is an idiot and he pulls up like right next to Tamir, who's got the toy gun,
Mhm.
and he puts himself in danger by exiting. And the way the grand jury looked at it is they only looked at it once he got out of the car, at that moment, was he in danger? And they didn't look at a wider range. And we're seeing that same problem in the Rittenhouse case. We're not looking at like why did he bring a gun with him that to where he came, and we're looking at some of this as well in the Ahmaud Arbery killing, where the judge is trying to focus pretty narrowly on what happened at that moment and keeping out some of the, earlier racist statements and things like that. That this is more clear in Rittenhouse, but it does remind you of what people have criticized with the excessive force cases for police. And we're seeing it playing out in the self-defense area as well, or played out in the Rittenhouse case. So that's one. And then there's also just the fact that if you take a look at Ahmaud Arbery's killers, one of them was related to the police department. So if we're thinking about like, well, what does it mean that it is essentially somebody connected to the police that is behaving like, executioner, a mob? What is that telling us about what we want the police to be doing? And if police are going to be acting like a gang, where like we protect our own, he's with us, so we're not going to charge, that is hugely problematic. And we've got to create rules for policing, given that this is the state we're finding ourselves in. I mean, basically, with Rittenhouse, ideally, you would want the police to be disarming him. That would be what you'd want. Remember, you talked about Terry and a little stop and frisk and take the gun away. Wouldn't that be wonderful if the police had done that with Rittenhouse?
Yeah.
But the police are handicapped there too, because of the lack of laws, or the laws in favor of open carry, so that that is making it harder for police to do that. But even so, it doesn't seem like police do see white men as the same threat, because he walked by them, if you remember, with the gun, and everyone is shouting, "Killer! He's the shooter! He's the shooter!" And the police still did not arrest him. So that's that backdrop. You have a combination then of the law and how the law works and how the law empowers police, and then you have sort of how the police are operating right now. And that's where efforts are, people have to think about, like, what do we want to do legislatively to change things here? And I think that the changes need to be big, not small. It's not a little bit about tinkering. And I think that getting rid of consent altogether will go a long way, because police will no longer be able to just start going up to people hoping that they, fishing expedition, that they'll get drugs. That's part of it. And that should also help with racial profiling, which is a huge part of this as well.
And both these cases have defendants who are alleging self-defense. And so I wanted to get your thoughts on, the Arbery trial, McMichael's defense attorney's argument that despite the gunshot to his right wrist, nothing prevented Mr. Arbery from holding the gun with one hand and swinging. How does that, as a former defense attorney, if you were in the courtroom, I mean, that just seems like such a stretch to me. In addition to the fact that both cases, the Rittenhouse case and this case, both involve white men who took it upon themselves to act as law enforcement, put themselves in a position to provoke a violent reaction or to provoke some kind of altercation, and now they're alleging self-defense. What are your thoughts on that?
Well, as soon as I read about the Ahmaud Arbery case, it reminded me so much of Trayvon Martin. When I gave a talk at Howard, I called it the ghost of Trayvon Martin. And it has some of the similar aspect to it, which is a white man brings a gun and then claims he needs self-defense because the other person is going to take his gun. And that is That's the argument that Rittenhouse gave too, and it's certainly the argument that the son, I always forget which McMichael it is, Travis McMichael has, oh, he got close to me, he could have taken my gun. I think that we should have a new law, and we could try it in some blue states first, that says if somebody is carrying a gun, then it's on them to keep a hold of the gun, and they should not be able to bring a gun where the other person is unarmed and then claim that he was scared that somebody else was going to take his gun. It should be on you. If you're going to be walking around and you think it's going to protect you, then you better learn how to keep hold of your own gun. And that kind of change in the law would update self-defense law to make it more relevant to situations where we have gun carrying, as if we're back to the Wild West, right? The success of the gun rights movement has been enormous. And so, they're about to, probably the Supreme Court is about to relax some of the carry laws, it looks like. And given that, we have to change self-defense laws. So what do I think about Arbery? I think there's so many fascinating issues there. So there, some of them ended up being things that we talked about in evidence class, because the evidentiary issues are a little bit entangled. But if anything bothered me in that case, it was the citizen's arrest law. The citizen's arrest law creates this huge problem because it allows somebody to be the aggressor, and at the same time says, even though you're the aggressor, you don't have to retreat because the law is allowing you to be the aggressor. And that makes it very, very complicated. But number one, after this case, they got rid of the citizen's arrest law, right, in Georgia. Thank goodness for that. But secondly, I think the judge is making an error when he gave jury instructions. Was it this morning? I think it was today. He gave jury instructions about the citizen's arrest. And he basically told the jury that they are allowed to consider citizen's arrest, and they have to decide whether they had probable cause or not. And that is a mistake. This is a question, this is a legal question. And if it was police officers, we totally know that this was a legal question, and it would be dealt with as a motion to suppress before the trial, right? So here the jury is being handed this information for them to sort through. This is problematic for two reasons. One is that it's a legal issue, but two, they don't get there. Basically, the way I read that statute, and I spent a long time looking at it when this case first came out, because I was giving a talk on the case, and it was a very confusing statute because there's two different sentences, and the question is sort of how the sentences go together. But the clear reading is it has to be a felony. It has to be a felony. It can't be a misdemeanor. And all that they were thinking about is that he had trespassed. I mean, if they had probable cause for anything, it would be trespass. And also they're supposed to have had firsthand knowledge, or, there's some language about something close to firsthand knowledge. I don't remember the exact language offhand without reading my paperwork. But maybe they could say that it was secondhand, but close enough. But there's no way that this is probable cause to believe that he had committed a felony. So the judge should have taken it out of their hands. The judge should have told them that the defense, that they couldn't even argue it. And I think that would have been a much fairer trial to the government. So to me, of all the evidentiary issues, that's the one, that jury instruction, that is the one that I find most problematic. Yeah.
Oh no, I was curious because in this citizens arrest law in Georgia, I know it allows citizens to go ahead and make these arrests if they reasonably suspect that these crimes are being committed. And so that reasonably suspected aspect of that law, is there any similarities between that kind of reasonable standard and the reasonable officer standard we were talking about earlier, that those who are trained law enforcement officers are, given more deference with. Now, in both cases, like, mistakes can be made, it seems, because as long as the circumstances would allow someone in that position to believe that there was imminent danger or imminent harm to them, they can go ahead and conduct the Terry stop we were talking about earlier, the stop and frisk, or they can go ahead and conduct this arrest in Georgia. Are there parallels or similarities between these two standards of reasonableness?
I think the statute gives a little bit more, a higher burden than that. It talks, I found it, the Georgia statute. It says a private person may arrest him upon reasonable and probable grounds of suspicion. So they need probable cause. And this is an objective standard. So I don't think that just their reasonable belief is enough. I think that they're arguing maybe that their reasonable mistaken belief is enough for them to get to the intent of what their intent essentially in a murder case. But you are supposed to know the law. Ignorance of the law is no excuse. So if they did not have, and it talks about it has to be committed in his presence or within his immediate knowledge. And it talks about felonies. The offense is a felony. So they did not have enough. So I would say that in this instance, the judge should have required more than whether they behaved reasonably or not. That I don't think should have been the standard. There are other issues that I thought that had to do with whether or not you're bringing in character evidence. They ended up being very interesting in this case. So I don't know, Mike, if you saw any of this, but basically initially the defense wanted to bring in the criminal background of Arbery, including the fact that he was on probation. And there was also a case from when he was had just graduated high school, and he went back to high school with a gun. And then they chased him, and they said, see, he wouldn't stop until the police chased him. That's similar to what we have here. And I thought the judge made the correct ruling by saying this should not come in. This is irrelevant and really does not go to the issues before the jury, and it'll just distract them. So that was a good ruling. But then when the defense tried to bring in that Arbery, the prosecution tried to bring in that Arbery liked to go jogging, and jogging was part of his routine, the way the judge looked at it is that would open the door to that other thing. And I'm not sure I would have ruled that way. To me, there's a real difference, because if you think about evidence, I like to think of it as like ground zero, like what happened that day is the most important thing. So what was he doing that day? If you look at the fact that how long can he jog? 10 miles is normal, etc. I think his jogging, the fact that he has a tendency to jog and where he jogs is very, very highly relevant versus something that he did, when he was 19 years old. What's the relevance of that? And so I think the earlier stuff was character evidence, but I don't think that the fact that he jogged a lot was about him having good character. I don't think that it's character evidence. It's more like understanding the background of the situation in which he found himself, in which he was there. But that is at least the judge gave a warning, right, to the prosecutor and said, hey, you're going to be in trouble if you go down, you will open the door. So I think the prosecutor made the right decision, and I'm not that mad at the judge for that problem. What about the racial epithet? That was really interesting, and that just developed this week. So what happened with the racial epithet was that Brian, who was the one who did the filming, when he talked to the police officer, he said the shooter stood over the body of Arbery and a racial epithet, a very ugly, effing, that kind of thing, right standing over him. It can't be more relevant than that. That is so important in terms of his state of mind, what's going on. But it was a statement made to police by Brian. So normally, in the normal course of things, the prosecutor has Travis McMichael on the stand, and he would say, didn't you say that when you were standing over the body of the man you killed?
Mhm.
And he could say yes, he could say no, and that would be the end of it.
Yeah.
But where I practice, a prosecutor would have good faith basis to ask that question, and a judge would allow him to ask that question. So this judge was interesting in that he said the reason he's not going to allow them to ask it is because it opens the door for a Sixth Amendment right to confrontation. I don't know if this is too geeky, but essentially what's going on is Brian is not taking the stand. And since Brian's the one that told the officer, then what Travis would want to do is put Brian on the stand to say, no, he never really said that. I was just making it up. But he can't call him to the stand because he's got a Fifth Amendment right. So the right to confrontation ended up sort of stopping that very, very important information from coming out. And again, it's one of those rulings another judge might have ruled differently. But maybe the case is going in well enough for the government that we don't have to worry so much about losing some of these evidentiary arguments.
So, Professor, you brought me back to your class in fall of 2019, Rule 404, which bars propensity evidence. In other words, you can't bring, like you explained earlier, you can't bring an instance from the past to show you acted like this in this instance. But there are some exceptions. And we do see in Rule 404B that one of those exceptions would involve, for instance, showing motive, opportunity, intent, preparation, plan, knowledge, identity, absence of mistake, or lack of accidents. Now, I know we were going to focus more on the Arbery trial, but I was dying to know because the judge really chewed out the prosecutor for this in the Rittenhouse trial. And that was for showing a video that showed Rittenhouse witnessing possible shoplifting and saying that if he had a gun, he would shoot the people. Now, because the defense's argument depended on the fact that Rittenhouse was there to really render aid, he was there to help defend property. He was only having the gun, he wasn't holding the gun to be proactively looking to start trouble, but he was holding it really for self-defense purposes. If that's the case, wouldn't it seem like you've already introduced your defendant's peaceful character into evidence, and therefore now the prosecutor, it's fair game for them to go ahead and pick that apart and say, well, if that's the case, then you wouldn't make such a statement about saying you wish you had a gun to shoot shoplifters. What is your opinion on that, and how it differs, or maybe how it's similar to the way the judge ruled in the way he barred character evidence in the Arbery trial?
Yes, that judge really chewed out the prosecutor, didn't he? That that was one of those moments I was like, oh, I'm glad I'm not a trial lawyer anymore. It's create a little PTSD, So yeah, I thought by the way, he chewed him out for one good reason and one bad reason. Well, he chewed him out for good reasons, honestly. So one of the reasons he chewed him out was because this prosecutor was trying to comment on the post-arrest silence of Rittenhouse. Now, Rittenhouse, if he had been properly arrested, the way most people are after they are commit a crime right in the presence of the officers or right near the officers, if they'd arrested him then, he probably would have made some statements. But as it was, he got to turn himself in. He had a lawyer by that time. So he never made a statement. And they were saying to him, they started cross-examining him and saying, oh, you never mentioned this before. You've been sitting here in the whole trial and you never mentioned this before. That is outrageous, right? I approve that the judge protects criminal defendants, and I don't think it's just white criminal defendants. I think he's a judge who understands the rights of all criminal defendants. From what I gather, there's a lot on the criminal justice listserv. That's my impression, that he is a honest judge. So and that really ticked him off, because no lawyer does that by mistake. They know what they're doing. The second thing that he did is he got a ruling from the judge about this 404B evidence that you're talking about. And that was about whether or not it would come in that he had, I really wish I had a gun and I could shoot people, right? That was a legitimate motion to bring that evidence in, a very legitimate motion. The judge could have ruled either way. The judge ruled against the defense, and yet, against the prosecutor, and the prosecutor kept trying to bring it in. And he did it. He didn't do it by going up to the judge and saying, "Your Honor, I would like to revisit your earlier ruling." Instead, he just decided that he could start slipping it in during cross-examination. And having been at trial when prosecutors tried those kinds of things, that's ugly. You're not supposed to do that. And
we spoke with attorney Lee Merritt tonight, who represents Arbery's mother, Wanda Cooper Jones. Merritt believes the evidence is overwhelming in this case to convict the three men, but says you never know which way a jury will go.
Has done such a good job taking care of the family. Right. And we've gone through some ups and downs. We've seen different prosecutors come in. We've seen different evidence argued.
Oh, it's me.
Yes.
Oh, that's so funny. You can. Sorry, let me get rid of it. Let me get rid of it. Oh my gosh.
No, that's no problem at all. And Professor Ross,
totally embarrassing. Okay, so what I was saying before we got interrupted, I thought you wanted to show some new clips.
No.
So it's all ears. So basically, that's why he got it chewed out. But I don't think the judge made the right decision. I think you were right, Mike. I think you were obviously paying great attention in my evidence class. Not a big surprise. I knew you were. And this is 404B motive evidence, right? His motive is so important. And it's germane to why he pulled out the shotgun and started using it. And it wasn't that long ago. It was part of the same demonstrations. So if I were the judge, I would have let it in. But that being said, I don't know Wisconsin law. And the way the judge talked about Wisconsin law, he acted as if general motive wasn't going to be enough. It had to be very, very similar. And that made it seem that he wasn't even thinking about it in terms of motive, that he was thinking about it in terms of two acts that are very, very similar. But it wasn't an act. It was an attitude. It was a state of mind. That's why it should have come in.
And, one of the most surprising, the thing that's really interesting about this case is that you have the judge, of course, he ruled that you can't call the folks that Rittenhouse shot victims. He ruled against that jury instruction. And then you also have the fact that someone survived the shooting and he took the stand. Gabe Grosskreutz. And I'm wondering, why didn't Gabe Grosskreuz's testimony hold more weight? Apparently, because if you have the person who literally escaped with his life testifying that he had surrendered, and that Rittenhouse actually recharged or re-racked, as he put it, his AR-15, that seems to just really be a devastating blow to the defense's side. What do you say about that?
Oh, it's hard to listen to it even. I so badly wanted Rittenhouse to be convicted at least of that shooting. There was a very clever cross-examination. But I just got to say, I agree that victims should not be called victims in the beginning of a trial, that is very loaded. And and I think that's done in every trial there. And there's a lot of judges that do that in every trial. So it would be one thing if it was only done in one particular case, but across the board, I think that is the way things should go. I think by the end, by the closing argument, you've earned your right as a prosecutor to call people victims. And similarly, he was saying that you couldn't call people looters and so forth at the beginning, that they would have to prove that they were looters. And if they did, then they could revisit with the judge the opportunity to call them that in the closing. And it never came up because they didn't prove it. So I think that was the media didn't seem to understand defense rights, the right of defendants not to have all this loaded language. So that was not a problem. The gun issue, I heard a couple of clips of cross-examination where the victim, and I'm going to call him the victim, ended up agreeing that he had his gun pointed at Rittenhouse. And you also could see that it was chaotic there, lots going on, and they are being told, look at it from the point of view of Rittenhouse. He's 17 years old. He's scared. He's in the situation, and he has a gun pointed at him. So I think that it also the way these self-defense jury instructions work, it's the burden on the prosecutor to prove beyond a reasonable doubt that there was no self-defense. And maybe that's a problem. Maybe we should start switching that up a bit and not having the prosecutors, especially if there's a gun, if there's a shooting, maybe the burden should be on the person who uses the shotgun to say that it was not self-defense. Because as you are pointing out, we're seeing too many of these cases, and Rittenhouse's verdict is sending a message that it's going to be open carry, so to speak, for going to Black Lives Matter and other important protests and coming armed and then claiming you're scared. And it makes it very, very scary to do what we need to do as a society and march and show where we stand and protect our democracy right now. Things are very, very fraught. And the idea that you take your life in your hands by going to a nonviolent protest is a really awful, awful fallout from the verdict.
And one of the surprising decisions by the judge for me was the fact that he dismissed the charge of possession of a firearm by a minor in this Rittenhouse case. He refused to allow this to be determined by the jury. And I know a lot of folks have made this a matter of the size of the barrel. Was this one of those situations where this was something that should have been, in your view, deliberated by a jury, being that Rittenhouse was 17? He came with a military assault weapon. This seemed to just be in alignment with textbook, element-based criminal law when it comes down to, whether or not he was guilty. What do you say, Professor?
I say that the law is bad, not the judge's ruling, but the law is bad. The law created this accidental loophole. I mean, the idea of it being over 16 inches is written into the way the law is written. And so the judge really did consider it at length, pun not intended, right? But he considered it, and there was even the prosecutor said we cannot prove that it was 16 inches or less. But that is the most ridiculous law, especially when you're talking about an assault rifle. I don't think that loophole was intended for assault rifles, but that's not up to the judge to say that's a stupid law. That right. Shouldn't be in effect. We're going to go by what probably the meaning of the legislature was at the time. No, it's the way the law is written. And so just like We've got to change some of the laws that involve self-defense and guns. That's an area that needs some updating. And just like they got rid of the citizens arrest law after the issue with Arbery, that's what we've got to do, is see every case. We got to see it as a terrible accident that is occurring, you know, and that it shouldn't be repeated. And so figuring out what needs to be changed, that going forward actually can have a bigger impact than just one particular case.
And when I interned with the district attorney's office, my, I guess, 2L summer, you know, I had the opportunity to engage with a lot of different victims, and you know, there was a victim of a rape case, and you know, she was an older woman, but the perpetrator of the crime was a young man, actually a minor. And I remember her saying, you know, she really felt bad that he was going to be charged with such, you know, a heavy charge. And so one of the staffers in the office said, well, if you commit grown men crimes, you get grown men, you know, punishment. And so I'm wondering, you know, being that the defense attorney told the jury, hey, look at this through the lens of a 17-year-old in Rittenhouse's position. Now I can think of many 17-year-olds, myself included, who didn't go out or wouldn't even think of the idea of going out with a military weapon strapped to their back. And then you saying, well, I had to bring this for my own safety. Do you think that was a, you know, a stretch in terms of, you know, saying a reasonable person in his position would react the same way? Was this kind of reasonable, like going back to the conversation we had earlier with that reasonable standard, was this in this case really too arbitrary to really meet the needs of the defense?
What strikes me is that he is a minor, and that we've been learning a lot about how the brain forms. And we know young people make stupid decisions, and they make it actually way past the age of 17, right? The brain doesn't really develop totally till age 25 or so. And that we have a problem with too many young people in this country being charged as adults. And it tends to affect young Black men more than it affects young white men. But maybe the Rittenhouse case just goes to show that when we try to squeeze a young person into a adult crime, it doesn't really mesh very well. If you're thinking about what we would want to do for young people, we would want to do a restorative justice approach, even for somebody like Rittenhouse, where he has to pay some kind of debt to society. But at the same time, you know, I don't think anybody does well wasting away the rest of their life in prison, or even, you know, 30 years in prison. It's really about how do we want to move forward as a society with less focus on punishment and more focus on giving people what they need to succeed. And we do need protection from people like Rittenhouse, who are coming to these places of peaceful protest and bringing weapons. But, you know, punishing one person, what'll that do? What really would help is if we make laws about that, and we can try to figure out a way that police can do this fairly, so that people are disarmed when they get into spaces where there is a peaceful protest planned. I think that is where we need to look. And, you know, so one person gets off. The only thing that is problematic about that is the message it sends to everybody else.
And before I, you know, leave you tonight, I want to get your thoughts on the implications that a predominantly white jury in both of these cases have had, or currently is having, in the Arbery trial. You know, it was weird to see Kyle Rittenhouse pick his jury out of a box. A lot of folks had questions about that, because they, you know, for a lot of people, this was the first time they ever seen something like that take place. I want to get your thoughts on that, and also the implications of a predominantly white jury for both trials involving white vigilantes taking it upon themselves to take the role of law enforcement and recklessly put the lives of others in danger and actually kill them.
It stinks. We still have a huge problem with people using the peremptory challenge in a way that is discriminatory and gets rid of minorities, particularly Black people, but Latinx, whatever group that is needed on that jury. And it's a big problem. The idea of getting rid of peremptories totally is one idea that's been floated, but there's some problems with that too, because you want to get rid of people that you think are clearly racist and get them off as well. So, and a lot of times the judge won't do it. So you need to use the peremptory for it. So it is a mess. And I thought that both trials really, when they're coming at the same time, showcase this and the problems with it, because it creates a question of legitimacy. Do we consider that the verdict is legitimate in Arbery if it's done with one Black person sitting on a jury? And the other issue that's very interesting is that even though it's a white vigilante, with Rittenhouse, all the victims are white. And so that's an important wake-up call. In my book, I'm saying, the fact that so many of the problems that we're talking about with stop and frisk and so forth affect men, and particularly young Black men and young Latinx men. Even that being said, that doesn't mean it's a numbers game. And then we have to look at what happens to women too, and girls. And we also have to realize that white people are going to get, once you start giving away all this power to the police, it's going to affect white people too. And here you could see the white people, because they're going to a Black Lives Matter protest, they're being seen with that same broad brush, that they are not the white people that, we're talking about with Rittenhouse and so forth. And I think that's maybe a useful thing for a lot of white people to see in that case.
Well, Professor, I want to go ahead and thank you for your time. This has been an amazing discussion. I've thoroughly enjoyed it. I want to go ahead and encourage the viewers to go ahead and could you share with them where we can find, your book, A Feminist Critique of Police Stops?
Well, at your local bookstore. I was in my local bookstore today at the Politics and Prose in Washington, D.C. It's in the window and it's in the bookstore, but you can get it on Amazon too if you don't support your local bookstore. And I recommend getting it in paperback. It's a lot less expensive.
Well, Professor Ross, thank you so much. It's been a privilege and honor to have your time. Thank you for being a part of this program, and thank you for making episode 53 such an amazing one. With that being said, I want to go ahead and wish everyone watching, and you, Professor Ross, a happy Thanksgiving.
Happy Thanksgiving to you too, Mike. It's been great to see you again.
Good to see you too, Professor. With that being said, I'm going to go ahead and conclude episode 53 of the Political Mic. Thanks so much for watching.